Good morning.
Good morning. Can you hear me?
I can.
All righty. Calling case number 24-4106, City of Royal Oak versus Brock. Where it is alleged that Ms. Brock, on or about February 4th of this year, committed the offense of disorderly and resisting arrest. Detective, please state your name for the record.
Detective Brett Nelson, City of Royal Oak Police Department.
All right, do you solemnly swear affirm the testimony you're about to give us true, best of your knowledge, information, and belief?
I do.
Please proceed with the facts established probable cause.
Thank you, Your Honor. On February 4th, 2024, Royal Oak officers were flagged down outside of Fifth Avenue Bar. It's located at 215 West 5th Street in the City of Royal Oak. They were flagged down to assist with a woman who was disorderly. Officers observed Kylie Brock creating a scene. She appeared highly intoxicated and she was yelling at her partner and yelling at bar security. She was using a rope partition to support herself and hold herself up. Royal Oak Officer Jones and other fully uniformed officers attempted to arrest Brock and place her hands behind her back. She struggled against officers, thrashed her body, dropped to the ground, and passively and actively resisted their attempts to control her. She continued yelling, and officers had to eventually carry her to a patrol car. Brock submitted to an administrative PBT. Her results were 0.24% BAC, and the Royal Oak City's Attorney's Office authorized charges for disorderly conduct and obstructing a peace officer. With that, Your Honor, warrant before you.
All right, the court finds the alleged crime was committed with probable cause to believe that the defendant committed it. I'll not be issuing any interim bonds. I'll be arraigning the defendant here in a few minutes. My inclination is to set some sort of a low cash bond, like 5,000, 10%, something like that. What are your thoughts with respect to any bond that might be set?
That sounds completely appropriate. See, looking at her history or lack thereof, looks like it was more of a alcohol-related issue that hopefully resolves itself when she's sober. So that sounds perfect.
Yeah, the court's usually concerned if you have like a resisting police or arrest or something like that. I'm usually concerned about them voluntarily appearing if they have personal bonds. So, all right, very well. Thank you very much for your feedback. We'll get her arraigned in just a few minutes.
Thank you, Your Honor. You have a good day.
All right, you too. All right, Royal Oak, can you hear me? Can you hear me in Royal Oak?
Yep.
All right, Mr. Seekley, you can hear me. Okay, Mr. Seekley, you can hear me, correct?
I can hear you fine.
Okay,
Thank you.
Can you hear me in Royal Oak?
Yeah,
Okay, are you Ms. Brock?
I am.
All right, thank you. Calling case number 24-4106, people of the City of Royal Oak versus Ms. Brock. You've identified yourself for the record. Counsel, please put your appearance on the record. I would like to proceed.
Good morning, Your Honor. Christopher Sakeley, bar number 23248, with the Michigan Indigent Defense Council, representing Ms. Brock for purposes of arraignment only with her permission. Is that correct, Ms. Brock?
Yeah,
Judge, we will waive formal reading of the complaints and she would stand mute.
All right, I'll enter not guilty plea for purposes of arraignment on Ms. Brock's behalf, and I will advise her that she is presumed innocent until proven guilty beyond a reasonable doubt. She's got the right to try the matter by judge or jury. She's got the right to remain silent. That silence cannot be used against her, and she's got the right to be represented by an attorney. She cannot afford an attorney. The court will appoint one on her behalf. Do you understand all that, Ms. Brock?
I do.
All right.
Judge, she's going to need to appoint an attorney.
Okay, very well, and thank you for that information. And based on the paperwork you've provided, I believe that that's appropriate, so I'll authorize that. Mr. Seekley, what do you have to indicate with respect to bond? My inclination is to set some sort of low cash bond.
I would indicate that would be appropriate, Judge. She has no prior criminal history. She's not on probation or parole. And I would ask for a personal bond or a very low cash bond.
Okay, taking into consideration the fact that she really has a lack of history, I think the bond should be lower personal. However, when we've got a situation where maybe there's a resisting police, arrest, something like that, the court's usually concerned that the person isn't going to voluntarily appear if they're given a personal bond for the next court date. So the court's going to set bond in this matter of 5,000 cash 30 or 10% of that, with the condition that Ms. Brock appear for any court proceeding, not leave the state without permission of the court. She notified the court immediately in writing of any change of address or telephone number, not possess firearms or other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs. I should say recreational marijuana or illegal drugs. No new criminal offenses, and she'll be supervised by pretrial services, who she must contact within 24 hours of her release. Do you understand all that, Ms. Brock?
I do.
All right, actually, I'm going to add random testing 1 time a week for drugs and alcohol. You understand that?
Yeah.
All right, you'll be notified your next court date. You're all set. Thank you.
Okay, thank you.
Thank you. All right, thank you, Verlo.
Thank you.
All right, Mr. Seekley, did they give you the information on the Novi people yet?
No.
Okay, all right, we'll get that to you. We've got 3 people in Novi, and then after that, I think we're going to the jail.
It's supposed to be lit
Yeah, it's on my ID.
with a JR.
That's a
section.
junior, yeah.
Okay.
Nah,
Okay, so
That's
it
why-
is Junior Jackson. Okay, cool. All right. All right, thank you.
Yeah.
All right, calling case number 24NO00308, people of the city of Novi versus Lynn Neal Hopkins, J.R. Jackson. Sorry, Mr. Jackson.
How you doing? Good morning.
Okay, are you Mr. Jackson? Sir?
Oh, yes. Oh, I'm sorry.
Oh, okay, thank you.
You
Counsel,
can move
please
a little
put
bit
your
closer.
appearance on the record.
I
I'd like
did.
to proceed.
It's kind of hard to hear, sir.
Yeah, I didn't know you was talking to me.
All righty. Counsel, please put your appearance on the record. How'd you like to proceed?
Good morning, Judge. Christopher Sakeley, bond number 23248. I'm with the Michigan Indigent Defense Council, representing Mr. Jackson for purposes of arraignment only with his permission. Is that correct, Mr. Jackson?
Yes, sir.
Judge, we waive formal reading. You would stand mute.
All right, I'll enter not guilty plea for purposes of arraignment. I will advise Mr. Jackson that he is presumed innocent until proven guilty beyond a reasonable doubt. He's got the right to try this matter by judge or jury. He's got the right to remain silent. That silence cannot be used against him. He's got the right to be represented by an attorney. If he cannot afford an attorney, the court would appoint one on his behalf. And are you requesting court-appointed counsel, Mr. Jackson?
Yes.
Are you currently unemployed?
Yes.
Okay, all right, I'll make that notation here on the form. Based on that, I believe you do qualify, so we'll assign counsel for you. With respect to bond, Mr. Seekley, just due to the fact that he's got like 3 or 4 outstanding bench warrants and a history of not appearing, my inclination is to set some sort of low cash bond, but I'll listen to your argument.
Well, Judge, I would ask for a personal bond for Mr. Jackson. He's not on probation or parole. He's 39 years old. He's unemployed. This is his first instance of some type of domestic situation. I think he qualifies for a personal bond. I would ask for a personal bond.
Okay, yeah, I do appreciate the argument, but in reviewing the information here, it looks like there is a criminal bench warrant out of the 36th District Court, a criminal bench warrant, another one out of the 36th District Court, a criminal bench warrant out of the Royal Oak District Court, a 3rd bench warrant out of the District Court in Detroit. It looks like there may be one out of Hazel Park too. So I do agree that ordinarily with this type of offense, it being a first offense, and I see Mr. Jackson doesn't have any real felony record since like 2006 or thereabouts. So ordinarily I would give a personal bond, but just due to the fact he's got these 5 warrants outstanding, I think some sort of low cash bond would be appropriate to ensure his appearance. So I'm going to set a bond in the amount of 5,000 or 10% of that, with the condition that Mr. Jackson not have any contact with Tatiana Wright, that he not harass the community or threaten any witness.
Hey, man, I ain't got $500. I ain't got
Sure,
nothing, man.
it's not going to get any better for you, Mr. Jackson.
I don't
you
care,
You must
just
man.
personally appear for any court proceeding.
I got a
in
black
state
eye,
without
man. My eye hurt, man. I'm
Immediately
messed up,
notify the
man.
court in writing of any change of address or telephone number, not possess firearms, other dangerous weapons, refrain from using any alcohol, marijuana, or illegal drugs, no criminal offenses, And he'll be supervised by the 52-1 Corporate Bond Compliance Program, who you must contact within 24 hours of his release. You're all set. Thank you.
Man, you say it, man.
Can you have them on? Get them back to you. So, yep. Actually, let me.
There's something in the water in the fire.
I think it's something you said, Chris.
I said, good morning.
All right, speaking of a parade, we'll talk to our,
Oh, I still got gun shock from that guy. PTSD. I gotta say, on all the arraignments I've done, I've never, and the crazy people that I've represented, I've never had anybody react like that.
yeah,
I just said, hey, go put him back in a cell. That's where it belongs.
yeah, that's,
Oh, fuck you.
we're gonna put that one at the end. We're gonna figure that
I
out.
can't wait to see how he acts with you.
It's gonna be, I'm trying to make it minimally entertaining. So,
Yeah, that's gonna be very good.
yeah,
We'll see if he exposes himself again.
Novi police officer.
Who's
That's
Logan
right.
Flynn?
She
Hey,
is one of my best friends
hey,
from middle
Mark.
school. In Novi.
All right, well, I don't
She
know.
works at Novi Providence.
That's probably true, but I don't know
Mark.
who, I don't know what all my.
Oh, it's probably told.
hey, Mark,
All right, I want to apologize, attorney, for.
that's all right. Are you Mr. Mark Van Weemers?
I can't see the judge. This meeting is being live streamed. There's some, okay,
All
fine.
right,
Yes, I am.
sir. Okay, great. Calling case number 24NO00304, State of Michigan versus Van Weemers. You're here to be arraigned. The allegation is that on or about February 3rd, 2024 in the city of Novi, that you committed the offense of malicious destruction of property with less than $200, which is a misdemeanor punishable of up to 90 days in jail and a fine of up to $500. You are presumed innocent until proven guilty beyond a reasonable doubt. You got the right to try the matter by judge or jury. You've got the right to remain silent, but that silence cannot be used against you. You've got the right to be represented by an attorney. If you cannot afford one, the court will appoint one for you. My inclination is to assign you counsel on this matter because you haven't filled out the paperwork, but I think based on your history, it'd be appropriate to get you some legal assistance. So I'm going to proceed in that fashion. And then with regards to your representation this morning, you had the chance. Where'd he go? Is he there? But
I'm listening.
It's kind of hard to hear, sir. That's all.
Peekaboo. All right, there you are. All right, so
Peekaboo.
I gave you the chance to speak to Mr. Seekley earlier. That did not go well, so you're proceeding without MIDC counsel this morning. However, I did read to you the charge and the possible penalty, and I went over all of your rights with you. I indicated we're going to be assigning you counsel going forward. With respect to bond, because of the nature of the threats that have been made while you've been incarcerated, the court does have concerns for the public, so I'm going to set bond in the matter in the amount of $500,000 cash surety, no 10% for the GPS tether prior to release. With following conditions, you have to appear for any court proceeding, not leave the state without permission of the court, and notify the court in writing of any change of address or telephone number, and they will have you back in front of a judge tomorrow morning. Thank you, Mr. Van Weemers. We are all set.
Wait, no.
Hold on, we're good.
You're all
We're good.
set.
What? You're
Thank
gonna
you.
talk, but I can't talk?
Well done.